Hi there. So I wanted to do a quick video for you guys about the recent decision which really touches on the intersection between family law asset transfers and capital gains tax rollovers. And it's a really timely reminder that if you're doing anything relating to transferring of assets under a family law consent order or agreement, then you need to be mindful that you are accessing the best tax and stamp duty concessions and optimizing the strategy for tax and stamp duty. So they made some really insightful comments in the decision that you shouldn't be too specialized and be looking at these types of transactions, at least from a professional point of view, in a vacuum, because we really need to consider the transaction holistically. So the decision was Ellison and Sandini Pty Ltd, and it went all the way to looking for appeal from the High Court. The leave for appeal was denied, but the federal court gave us some really useful guidance about the capital gains tax rollover relief in section 126-5 of the tax legislation. So we had a section 79 family law court order where we're dealing with a transfer of $2.5 million worth of listed shares from the husband's related trust to the wife's related discretionary trust. And the issue was whether the transfer was going to be eligible for the 126-5 rollover relief. Now, if you read 126-5, it's pretty clear that the transferee has to be a spouse. And the decision came up with some, looked at different arguments about, well, is it enough that it's transferred to the family trust by direction of the wife? Anyway, they ultimately held that no, the recipient has to be the wife, so it was not eligible for the rollover relief. So that's useful guidance in terms of interpreting that section, but also for family law practitioners and any advisors who are assisting in the strategy of asset division to remember that there are rollover concessions out there and you should be optimizing their transaction, or at least considering who the recipient of assets should be, so that we're not looking at adverse tax consequences. So very interesting. I don't have any inside information here as to how the tax on the $2.5 million worth of listed shares is going to be managed from an advisor perspective, and if there's any buts on the line. But there could have been a better way to structure this by transferring the shares to the wife directly and not triggering that tax bill. So interesting decision. Ellison and Sandini Pty Ltd thought it was a very timely reminder for advisors not to look at family law transactions in a vacuum. And if you do want any assistance with tax or stamp duty outcomes on transfers under family law concessions, I'm always happy to help share some insights and guidance. Thanks for watching.